Hi, everybody. Thanks for visiting AskImmigration.com. My name is Patrick Metcalf. I'm an immigration attorney. Today's topic is immigration court. There are many things about immigration court, but I just want to give you some broad overview of what's happening with immigration court. So typically, immigration court starts once you receive a letter from immigration. It's called Notice to Appear, or NTA for short. Another way for the immigration court to get started is when you get arrested, when you are in jail, being held by immigration detainer. So a few things, actually quite a bit of things. Immigration court, you can defend, or we call it, you can defend your immigration court in many different ways. So I have about 10 different ways to do it. So let's go over them one by one. So I'm going to list them out, and we're going to go over those one by one. So this is going to be a little bit longer than my typical 1 or 2 minute videos. So please stay with me because this is important. First, fight the NTA. Sometimes, so let's go over all those 10 items. 1, fight the NTA, or fight the Notice to Appear. 2nd, apply for asylum, withholding, and CAT. 3rd, apply for cancellation of removal. Now there are 2 different types, one for permanent residents and 2nd for non-permanent residents. You can apply for U visa. You can ask the judge to give you a green card. You can ask the judge to leave the country voluntarily. We call it voluntary departure. Sometimes you can ask the DHS, Department of Homeland Security, for Prosecuttorial Discretion. And there are also a separate different motions and waivers you can ask. And finally, you can ask the immigration judge to suppress information. Say, hey, how did you get this information? It doesn't actually belong there. So let's get started. 1, fight the NTA. You can fight the validity of the NTA if the Department of Homeland Security improperly filed the notice. You may have some other means to fight and ask for a judge. Hey, judge, this NTA is not valid. So you may be able to get the case dismissed. And 2nd, this is one of the most common ones besides cancellation. So this is asylum, withholding, and CAT. Asylum, as you may have heard, you apply for asylum because you're afraid to go back to your home country. Because if you go back, you may be harmed, tortured, or even be killed. But remember, you're supposed to do that within 1 year. If you miss the 1 year period, then you're not going to be able to do this unless some exceptions in changing circumstances. So when those cases go more than 1 year, by the time you apply for the asylum, then you can request what you call a withholding or removal. You're not going to get the green card this way, but at least you get some benefits. And 3rd and finally, we call it CAT. It's United Nations Convention Against Torture. The bars are quite high, but at least you don't have to go back to your home country because you can convince a judge. It's, a judge, I can't go back because I'm going to be tortured. That's what it's called, the Convention Against Torture. 3rd, cancellation of removal. Just like what it says. You are canceling the removal, or commonly known as deportation process. Remember I said earlier there's 2 different kinds, right? One for permanent residents, other one for non-permanent residents. Permanent residents. You can ask a judge to cancel the removal process if you've been here for in total time physically in the U.S. for more than 7 years, and you've been a permanent resident for 5 of those 7 years. So then that's number 3. Number 4 is cancellation of removal for non-permanent residents. This is, again, very common defense, or we call it the relief in immigration court. You have to have 4 things done. Number 1, you must prove that you've been here for at least 10 years from the time you enter the country and from the date of the NTA. So those, you must have minimum of 10 years. So number 2, you must have qualifying relative. What are qualifying relatives? That is your spouse, your parent, and your children. So when you look at your arm, 3 different ways. Your parents, and your spouse, and your children who are either permanent residents or U.S. citizens. That's number 2. Number 3, you must be a person with good moral characters. So let's say if you got caught doing of DUI, or you got caught robbing a bank, those kind of things are going to basically not qualify or disqualify you from being a person with good moral character. And number 4, this is again, usually that's the most difficult part to establish. You must prove to the judge that should you be deported or removed from the country, your qualifying relatives will suffer exceptional and extremely unusual hardship. Yeah, it sounds long and it is very difficult to get. So moving on. Another relief we've been doing is U visas. U visas when you're harmed by somebody committing a crime against you. You must remember, for U visas, you must show that you are harmed either physically or emotionally as resulting from that crime. So you have to show that a victim of a certain serious crimes, you suffered a serious ongoing harm as a result, and again, you have to be able to support or prove that you are supporting the police in terms of investigation. So you are cooperating to bring the perpetrator to justice. So again, talk to a lawyer. There are lots of good immigration lawyers out there that can help you out. Number 6, adjustment of status. Yes, you can ask a judge to give you the green card. Most common ones are based on U.S. citizen or U.S. citizen spouse, so you can adjust your status. So if you're eligible, the judge can give you a green card. Voluntary departure, which is number 7. That means if you don't really have any of the other reliefs I spoke to you about earlier, well, you can ask a judge, can I leave early? Because I really don't want this deportation on my record. So you can leave on your own, and then you can find some other ways to get back in later. Number 8, prosecutorial discretion. Now this is a relief. You ask Department of Homeland Security, not the judge. So DHS can give you or they can approve you a PD or prosecutorial discretion, saying, all right, you know what, I see you do have a good merits, even though you lack any good relief, but you do have a good background, lots of family members, you've been a good person, so they may grant you the prosecutorial discretion to let you stay here. Motion to suppress is number 9. That means, let's just say you feel like immigration has been unfair. They've been targeting you. You really don't deserve this bad treatment. You can ask the judge to suppress some of the information that immigration has to use for your deportation cases. And number 10, finally, is other information. This is a catch-all phrase. There's some type of waivers, for example, 212H waivers, 212C waivers, and any other waivers you may be able to apply to avoid deportation or being removed from the country. So those are very brief 10 items. Okay, so as I said earlier, there are lots of good immigration lawyers out there. Find somebody who you can work with. I'm sure there's a lot of immigration lawyers around you. If you have any questions, you can call us. My name is Patrick Metcalf. I'm an immigration lawyer. Our phone number is 847-882-1992, and our website is www.askimmigration.com. Thanks for watching. Have a good day.